कहां से शुरू करने का है कुमार? Which is the section we have to start now?
Sir, we have to do section 64. I will open up right now.
Yeah, all these sections, in fact, we have initially discussed. They may not take much time, isn't it? जब शुरू किए हमने secondary evidence, primary evidence, all I have taken you through, isn't it? If I'm not mistaken, 3 lectures, initial lectures were devoted on this, taking you through the entire provision. So, देख लीजिए आप, section 64, that is primary evidence, how you lead the primary evidence. How you lead the primary evidence, but the document by itself. You cannot, the original document must be proved by producing the original document in the record. That is also the mandate of section 64, read with the provisions of Order 13, Rule 1 CPC. I mentioned to you that. That is the original document. When the original document is lost, when the primary evidence is lost, then you are required to lay the foundation for secondary evidence. You have to inform the court, you do not have the original on record with you. The original has been destroyed or the original has been lost. Then you have in the nature of copies, or the original may be in the possession of the defendant, XYZ government authorities. When that is the stand taken by any of the parties, either in civil cases or criminal cases. Let us take, for example, you took up the contention before the court that you do not have the original document. The original document is in the possession of the defendant. Then in that event, kya karenge aap? You will call upon the defendant to produce the original document. That notice provision is there under section 66. Ye pad chuka hum hai, I don't want to again read waste your time. Rule as to notice to produce. This notice should be given by you at the time when your witness is in the box, calling upon the other side that here I have filed my evidence and evidence and also list of document. And as regard the documents in serial number 1, 2, 3 are concerns, the original documents are in your possession and I only have Xerox copies. I would request you to produce the said original documents before the honorable court on the next date of hearing until the witness is discharged. वो notice दिखाएंगे आप section 66 के. Please note that. ये notice is mandatory to be produced. Without this notice under section 66, we say that secondary evidence of a content of a document referred to in 65, clause A. Clause A is a 65A deals with a situation that the original appears to be in the possession and power of a person against whom the document sought to be produced. Or the will document original may be with the registrar of sub-registrar. You are seeking to prove that the will has been signed by your grandfather in the presence of 2 witnesses. The will has been registered. Then notice आप देंगे registrar को, sub-registrar को, pleasing requesting that here the matter has now reached a stage of evidence. I have applied for probate of the document, and in order to prove the document, you are requested to produce the original document itself before the honorable court. That is a notice under section 66. And then suppose, for example, you are filing a suit for specific performance of a contract. The original document is in the possession of a builder who told you that it is sent for registration. Registration ke baad, he kept in your custody. His custody did not give you. His intentions were not good because the rate of the property when you had booked were less, maybe 1,000 rupees per square feet. Registration करने के बाद property was shot up in cities like Bombay, Calcutta, Madras. Maybe 1,000 की जगह 5,000 रुपया हो गया. So the builder is expecting more money from you. So you will file a suit for specific performance of a contract, asking him to perform the part of the contract you are ready and willing to be. And you do not have the original document, you will give a notice under section 66. Look here, gentlemen, pursuant to the agreement between you and me, I booked the flat and I have paid all the consideration and I am ready and willing to perform the part of my contract, which is sufficient compliant with the provisions of section 16C of the specifically fact. because section 16C clearly tells you the plaintiff must perform the part of the contract. The right to sue will be under section 10 of the and read with section 16 of the 15 of the specifically effect. You have a right to file a suit for specific performance of a contract. That suit relief sought by you is that that the that the suit be decreed, that this honorable court be pleased to declare that the agreement of sale is valid, subsisting, binding upon the defendant and both the parties. Number two, that this honorable court be pleased to direct the defendant to specifically perform and enforce the agreement, namely convey the flat and put into possession. That's relief you are sought seeking under section 22 of the specifical effect to put into possession. These are complete and effective relief. So at the time when the trial takes place, that before the trial, then because in the list of document you must have mentioned this under the provisions of order 7 rule 14 of the code of civil procedure, ये document mention किया आपने, and also under 11(3) आपने mention किया आपने, and the affidavit of document you tender before the court under the provisions of order 11, both 11, 12 and 13, इसका reference किया आपने. Then you notice under 66 should be given to the builder, calling upon him to produce the original document. Failing which, the Xerox copy in your possession which was given to you will be admitted. Number one situation. Number two, 65B के situation में where the course of activities carried out by the official information supplied in view of the store processing for the computer. Yeah, this is a 65B deals with a situation. The electronic records are with you. You have taken मोबाइल में आपने ईमेल मैसेज दिया है, सीसीटीवी कैमरा में रिकॉर्डिंग किया है. That recording of the CCTV camera is a secondary evidence under section 65B that will become that will become admissible when you have requested the authorities under the Information Technology Act under section 65 under section 65B subclause 4 check karo aap. Subclause 4 says that in any proceeding where it is desired to give a statement in evidence by virtue of the section, a certificate doing any of the following things, that is to say, identifying the electronic record containing the statement describing. तो यहाँ पे आपको सर्टिफिकेट के लिए अप्लाई करना पड़ेगा. This certificate के बगैर your evidence is incomplete. This particular provisions of section 65B relating to the secondary evidence was the subject matter of the Supreme Court in the famous judgment of the Arjun Pandit Rao Khotkar's case. I think I gave you reference in 2021. 3-bench judgment of Justice Rohinton Nariman. वो देख लीजिए, they have set aside overruled certain earlier rulings, and that judgment is a very useful judgment that tells you at the time you must immediately start proceeding. The moment document आपके कब्जे में आ गया, you write to the information technology officer, please give certificate. अगर आप certificate नहीं लेंगे तो ये document will be useless. This is a second situation. Number third situation, 65C के अंदर, when the original has been destroyed or lost, when the party offering evidence continues. So number 3 is a situation secondary evidence can be lost, that the document has been lost, rain के अंदर चोरी हो गया आपके घर में. Better take precaution to lodge a FIR. Go to the local police station, tell your client to lodge a FIR, placing on record the document in question, original document which were kept in a locker, I have been misplaced or lost, I am unable to find the same. You must make a statement before the court despite best diligence, and you cannot trace it out, but you have Xerox copies which are taken down from the original, which were in the custody of your lawyer or maybe charter accountant, bank locker mein, I produce the same. These are the same. Then the document can be admitted. Then D ke andar dekhiye aap 65D, when the original is of such a nature has not been easily movable. Easily movable mean it may be something a gigantic item. Photograph खींचे हैं आप, it may be an item which cannot be movable before the court of law. You can say that here I have taken photograph. Himalaya mountain mein your inscription is given of your father, grandfather's name. or a tomb in a graveyard where the property sought to be is in dispute of a gentleman who allegedly died on so and so year. What is the custom prevailing? So you cannot bring the tomb to the court of law. You can take photograph and bring it here. You can inform the court inscription given in the tomb, or the dates written in a certain mountain, or some inscription in temple, or some customs and usages which are sought to be established. I have brought them, got a copy, or the court has been pleased to appoint a court commissioner under Order 26 Rule 9 CPC for elucidating the subject matter, and under Order 39 Rule 7, where inspection has been taken by experts and their evidence may be taken on record to prove this document. Okay, this is another situation. The last is when the original is a public document within the meaning of section. So a public document such as your ration card, that is your passport, your election record, you need not examine the president of India, who is the owner of the passport of India. You need not examine the election commission under Article 124 of the Constitution of India, who is the authority for managing the affairs of the election. So a certified copy is sufficient to prove before the court of law. A certified copy is a public document, is a what you call it, a secondary evidence within the meaning of section 65 63 check करेंगे यहाँ पे 63 के अंदर certified copy given under the provisions is a secondary evidence. 65 1 copies made, number 2 copies made compared, number 3 copies. See, there are 5 illustration. What are the various documents which are which can constitute what secondary evidence? Primary evidence, section 60, 60, 62 and 64, the original document. 5 items are secondary evidence. How the secondary evidence can be proved? Section 65 में item number A, B, C, D, E, F, G. G देखो, these are the items which tells you the circumstances. Then F, when the original is a document with certified copy is permitted by this court by any other law in force in India to be given in evidence. So when the document which is certified copy of a foreign judgment under section 1314 of the Code of Civil Procedure will be accepted as a copy, as a secondary evidence in the matter here. That is the example here. F check here. Then G check here. When the original consists of a numerous accounts of other document which cannot be conveniently be examined in the court, and the fact be proved general results of the whole collection. So we mentioned to you that the documents can be made, agreement of sale, you can make 3 copies. There are 3 sellers, and 5 purchasers. So 8 copies can be made. So I need not prove each and every document. So one document can be proved in the possession of one of the persons here. So that will become a secondary evidence made in a certified, in a original document, namely stamped document, which has been sufficiently stamped under section 17 of the Registration Act. Copy hai, it will become proved here as a secondary evidence. Then the illustration G, when the original consists of ho gaya G. So these are the examples where evidence can be laid. So what you must remember that in the case of original which is lost FIR, in the case of the document in the possession of third parties, defendant, then give a notice under section 66. Don't forget to give notice under section 66, very important. If you don't give notice under 66, then you will not be able to prove the document. Yeah. Anybody want to ask any question on this primary secondary evidence before I shift to section 67, 67A? कोई डाउट है किसी को? या 67 पे आ जाइए. Proof of signature and handwriting of a person alleged to have signed or written document produced. If a document is alleged to be signed or have been written wholly or in part by a person, the signature or handwriting of this or so much of a document is alleged to be in the person's handwriting must be proved in the handwriting. So merely protection of a document letter is not sufficient. You must lead evidence to show that this particular notice is written by my grandfather in his own handwriting. I know his signature because I have been usually following up his constitution. So somebody known somebody knows the signature or the person deponent is alive, he must give a notice. Mere production, mere exhibition of a document is not evidence. So the contents of a document must be proved, the signature must be proved. That is what section 67 tells you. Okay. 67A, proof as to electronic signature, except in the case of a secure electronic signature, any subscriber alleged to have been affixed electronic record fact, such electronic signature of a subscriber must be proved. So this is required to be proved if the original is there under the provisions of section 65A, that is the original itself. Section 65A, special provision as to evidence relating to electronic record. So if you have got the original document itself, आपको sign signature मिला है बैंक से sign करने के लिए original, that itself can be proved under 65A. But if it's a copy of the signature sent in various documents, then 65B must be followed. That is a certificate from the information technology officer must be proved to prove the document. Okay. Then 68 is important. Proof of execution of a document required by law to be attested. Now, certain document which require attestation. I mean, will. A will is not valid unless two witnesses sign it. A mortgage deed is not valid unless the witnesses sign it. Now, how do you prove this? This is what section 68 said. If a document is required by law to be attested, you know that in the under the Indian Succession Act, the will has to be attested by minimum two witnesses. Under the Transfer of Property Act, the mortgage deed must be attested by two witnesses. It shall not be used as evidence until one attesting witness has been called for the purpose of proving its execution if there has been attesting witness alive and subject to the process of the court and capable of giving. So when you lodge a will for a probate in a district court or in high court in Bombay, OCJ, your will itself will not become a document, it can be proved. And what the law says that here, after lodging the petition for probate, at the time when you are recording evidence, you must tell the honorable court the will has been attested by two witnesses, Mr. X and Y. X is not alive, is dead. Y is alive, and I will examine. You have to examine one of the witnesses. If the witness is not alive, then there is a provision here. Somebody who knows the signature can be examined. See the proviso. Provided that it shall not be necessary to call a attesting witness in proof of the execution of a document not being a will which has been registered in accordance with the provisions of registration. So under the Indian Registration Act, registration itself is a tantamounts to proof, yeah, because the law presumes that a registered document is a genuine document, unless the other side challenges it's a sham, colorable, bogus document. So Indian Registration Act के अंदर there's a provision section 30, if I'm not mistaken. If you have got Registration Act, निकाल लीजिए. Anybody has Registration Act? I think I pointed out to you when teaching. I'll give it to you provision later on. Under the Registration Act, the law presumes that even Transfer of Property Act के अंदर भी पढ़े आप section 3 and 4 and 5 and 6 है. The registered document is the court will take a judicial notice of the fact that this document has been introduced, unless a fraud has been perpetrated. So by virtue of section 44 of the Evidence Act, any fraudulent document can be challenged. If the fraud is perpetrated following the Supreme Court judgment in the Chengal Naish's case, a fraud can be challenged at any stage. That following the provisions of section 17 of the Limitation Act, when you discover the fraud. Because some judgment of the Supreme Court say that your limitation is not applicable to when the fraud takes place. A decree which has been fraudulently obtained is nullity, and the fraud can be, that fraudulent decree can be challenged at any stage, at stage of execution, first appeal, second appeal, Supreme Court stage. That is the following the provisions of section 47 under the provisions of you can challenge the decree, the nullity. Nullity क्या है is not expressed in the CPC, CRPC or Evidence Act. It is a judgment. It is coined by the Supreme Court in many judgments, including the judgment of Chand Pasha's case of the year 1950. I think at the time when I discussed with you the Code of Civil Procedure, that judgment we must have covered it. If you don't remember, I'll give it to you again. So, a decree which is fraudulent can be challenge attended. Similarly, a document which has been fraudulently introduced in evidence can be challenged at any stage. Please note that here. So it is mandatory to prove one of the attesting witnesses. When attesting witnesses are not alive, see section 69. Proof where no attesting witness is found. When witnesses are not found, you know the provisions of section 32 of the Evidence Act. Persons who cannot be called. Let us see what it says. If no such attesting witness can be found, or the document purports to have been executed in the UK, it must be proved that the attestation of one of the attesting witness least is in the handwriting and the signature of a person executing document is in the handwriting. So you can examine the wife, the husband, the son, the secretary, the typist, the junior of the person who signed it. If the attestation is done by a solicitor who is no more, and evidence can be laid of the solicitor's junior or the solicitor typist who took it. Yes, in our present, the solicitor has signed it. So it is not necessarily mandatory that person must be examined. Somebody familiar with the signature can be attested. 69 requirement, the person who has signed it must come. 69 say that when person is dead and not alive, not to be found in the circumstances mentioned under section 32 or maybe 33, somebody familiar can be with the signature can be shown. Now see 17. Admission of execution by a party to assess a document. The admission of a party to attest a document of the execution by itself shall be sufficient proof of the execution as against him, though it may be a document required in law to be attested. So sometimes other party, the siblings may accept it here, some of the siblings, that yes, it is our grandfather made the will. So when there's acknowledgement here, you know that we learned earlier the provisions of section 58. Admitted facts need not be proved. Open section 58. Admitted fact need not be proved. So no fact need be proved in any proceeding with the parties here to agent agree to admit. So here, by virtue of section 70 must be read along with section 58. It's an admission. Somebody is admitting where there is no question. You need not bother to examine anybody and waste your time and time of the honorable court. So 70 is very important because some of the you can call out the admission. What is an admission? You should know the provisions of again section 17, 18, 19, 20, 21, 22, 23 of the Evidence Act. Evidence can be express, oral or implied. You gather it. And what are the admission constituting the provisions of Code of Civil Procedure Order 12 में पढ़े आपने? Isn't it? Order 12 के अंदर notice दिया आपने, you please admit. Interrogatories दिए. Interrogatories में admission है. Then he cannot retract it. Having given admission earlier, if you retract it, you call, there's a doctrine of waiver against you. There is an estoppel against you. Having consented earlier, बाद में उठ के you cannot take a somersault document मेरा नहीं है. नहीं, that is dishonesty. You cannot be permitted to approbate and reprobate in the eyes of law. So that is the concept here introduced here under section 70. Admitted fact need not be proved, which is the basic law under the provisions of section 58 of the Evidence Act. And admissions, you learnt it 17, 18, 19, 23 tak, and the provisions of order 12 CPC and certain other relevant provisions. Okay. Yeah, anybody has any doubt, please ask me. Proof and 71. Proof when attesting witnesses denies the execution. Now the gentleman having signed the document and he takes a somersault, बोलेगे मैंने नहीं किया है. देखो, if the attesting witness denies or does not recollect the execution, its execution may be proved by any other evidence. You may declare him hostile witness because that hostility, you may say that you have been bought over by the other side. You declare him a hostile witness. Under the provisions of section 150, 154, you have a right to ask your own witness questions, not in examination chief, in cross-examination. My lord, he is supposed to be my witness. He has been bought over by my brother or sister-in-law who have a vested interest and they want to give me a share in the property of my father. So the witness whom I cited under the provisions of Order 16 Rule 1 as my witness is not supporting me. So permission, I am seeking him to declare him as a hostile witness and I may be allowed to put questions in cross-examination. Number one, that is one mode. Or you may tell the court, this gentleman is denying his signature. this honorable court be pleased to ask him to compare his signature may be taken down. That is section 73 may be invoked. 73 comparison of the signature writing seal of the admitted. Let him show his passport, or your honor may please to ask him to sign him in the box. See that? Yeah, 73 खोलिए आप. Comparison signature legal seal within the admitted signature. In order to ascertain whether signature writing a seal is that of a person by whom purported to have been written or made signature, written down permits action, the court having been written made by a person may be compared, which is to be proved, though the signature writing seal has not been produced, proved. So you can make an application under 73. This gentleman having signed the will, having admitted an earlier proceeding, now he takes a somersault. He says he has not done it. This honorable court be pleased to ask him to sign in the box. Compare. He has signed certain wakalatnamas, they may be called. He has signed certain document in the High Court, British Civil Court, Criminal Court. The witness summon be issued to that court and the protection. A letter of request be issued to get the document. Or his passport be produced before the court of law. So there are lots of modes, not to get disappointed कि ये witness support नहीं कर रहा आपको. Support, you can nail him down provided you know the law. As a young lawyer or a lawyer cross-examining a witness or a trial lawyer, you should know the provisions of law thoroughly. Then that's a tool. You can declare him a hostile witness. You can under invoke section 73 of the Evidence Act comparison, or you may even request the handwriting expert to give opinion as to whether the signature is his signature, similar signature, not signature. Expert opinion can be sought under the provisions of section 47 onwards, which we learned it here now. Isn't it earlier? Don't remember this. Forget this section 45, 46, 47. Expert opinion can be sought. So there's the other mode. Or somebody familiar can be examined by the court. You can nullify his evidence to show that he has turned dishonest, he's turned turkey, he's taking a somersault with vested interest. Okay. So these are the various ways under the Evidence Act recognizes for proving the signature of a attesting witnesses. Section 68 से लेकर 68 से लेकर 72, अभी 73 में अभी कंपैरिजन सीख लिया आपने, देख लिए. ओके, देन 73A में आ जाइए. या 73A, proof of verification of digital signature. Now this is a in order to ascertain whether a digital signature is that of a person by whom it purports to have been fixed, the court may direct the person of the controller certifying authority to produce the digital signature, another person to apply the public keys listed in the digital signature certificate bearing the digital signature purported to have been made fixed, so and so. So यहाँ पे the court will say issue summons here to bring the application made by him to the authorities for when he has applied for a signature, digital signature, which he is now refusing here. That is there. You should know that. Explanation for the purpose of the section. Controller mean a controller appointed under section 17 of the information technology. So when the information technology is regularly being invoked recently of late, because you depend on computer system. So as a lawyer, you should not only be knowing the provisions of procedural law and adjective law, but also the Information Technology Act, which is both a procedural and substantive law relating to electronic records, and you must maintain, and you have a right to summon them and obtain certified copies and issue the officer, and he has to come to before the court. Okay, these are the various mode. Okay, then 74 के अंदर public documents we have mentioned. When the public documents become secondary evidence, they are you need not call any of the maker of the document. See, the following documents are public document. ये सब पढ़ चुका हूं पहले मैं, but I am recapitulating your memory. The documents number one of the sovereignty of the authority of the government of India, parliamentary states, उनके official bodies, tribunals, jitne bhi seals of the government, Supreme Court, High Court, all tribunal, they are public document of the public officer, legislative, judicial, executive, or any part. So all the government, semi-government, all persons who are instrument or state or a instrumentality agency of the state within the meaning of Article 12 of the Constitution of India, they fall within the Grama Panchayat, municipality, Tahsildar, the Talati, all these officers, revenue officers, they're all documents which are coming from the custody of public document. You need not call them to the court. Certified copy apply kijiye, produce kijiye. That evidence is applicable under section 65A, which says that 65 bhi padhe humne. Section 65A tells you once again for your 63(1), secondary evidence mean include certified copies under the provisions hereinafter contained. So you must remember 63(1) to be connected to the provisions of section 74. So these are all a certified copy taken by you from the government law college, mark sheet taken from them, true copy. You need not examine the principal madam as your witness in that regard. Yeah, copies you are taken from the University of Bombay, the certificate of eligibility or migration taken from your college university. You need not call them. Copy is enough, or originally not the certified copy is enough. So they are all there. Then 75 says that all other documents are private document. Private document mean or your private person letters, your diary, all agreements other than emerging from the public authorities under 74. Then 76 says certified copies are public document. Every public officer having the custody of a public document which any person has a right to inspect shall give that person on demand copy of the payment of the legal fees. Like under the RTI, Right to Information Act, you apply for certified, you are bound to get it here. Together with certified written on the foot that it is the true copy of the document, part thereof, as the case may be, and such certificate shall be dated, subscribed, and such which has been named, and certificate shall be sealed when the officer authorized by law to make it, and such copies. So you lost your original document and or you are producing before the court of law the original grant or a lease, head lease, which is in the office of the registrar, certified copy apply kijiye, produce kijiye. Isn't it? That certified copy under the seal of the officer, the responsible officer, you have to prove that this has been. So it's a secondary evidence under section 63(1). It becomes straightaway admissible. Explanation. An officer by the ordinary course of official duty is authorized to deliver such copies shall be deemed to have the custody of such document within the meaning of. So the person who issues the copy, you have lost your passport, original passport, then you apply for a copy. They have another original one. So the copy which they are giving to you after comparing the earlier copy, the head lease copy which you lost it, or your ration card, or your maybe election record which you have lost it, whatever reason. Aadhaar card is also comes within the mischief of public document issued by public authorities. So if it is issued under the seal and signature of the officer, it is sufficient proof to show that. 78 pe aa jaiye. Proof of other official document. The following public documents may be proved as follows. Number one, act and orders notification of the central government in any of its department of the representative of any state government or department. So all the notification issued by the parliament, either under the provisions of list the you know that both the parliament, the central government, state government are legislating under the provisions of list 7 of the Constitution of India. A, B, C, D, state list, central list, conflict. So the notifications are issued. I will just close it. I'll close the lecture. Sorry. Yes. Sorry. Yes. Yes. All the state government, central government, public authority documents are public document. Then record of the document. Then the illustration by any of the document printed by any of the crown representatives, be proceedings of the legislature. Legislature के जितने भी proceedings हैं, they are all public documents because the parliament or the legislatures both the central government and state government legislating under the provision under the Constitution of India, legislative powers of the parliament and the state bodies. Then the journals of those bodies respectively publish as a abstract and the copies purported to be printed the order of the government. So the Gazette of the government of Maharashtra, the MGG of the government of the state, which are now lying in the High Court, Government Law College Library. The Gazette, you need not call the Under Secretary of the state government to prove it. The copy, if you produce it, sufficient enough, isn't it? Then proclamation orders regulated issued by the Majesty under the provisions of the Constitution of India. Yes, the you have a chapter called emergency provision, which are borrowed from the German Constitution by India. So when a proclamation is issued with the President of India, when some suspensions of some of your fundamental rights, except a right under Article 1921, cannot be suspended, other rights can be restricted by the government. So notification will be issued pursuant to the emergency. It has been done so. Although all documents which are published, they are public document, can be used in the court of law. Either you are challenging the emergency, either you are supporting or not supporting the constitutional validity. Those documents can be utilized. Then the copies extract of the London Gazette, yes, I think before the partition, London का नाम याद आता है, अभी लंदन की जरूरत नहीं पड़ेगी. All then the act of the executive proceedings of the legislature of the foreign country. So even the proceedings of a foreign country are a public document which they are sought to be relied upon. Like we rely upon the judgment of the Privy Council, judgment of the US English courts are very often cited before the Supreme Court and High Court and lower court. And we often cite the English judgments. They're all public documents under the law. Journals publish authority. All the journals which have been published under the authority of any government, central government, state government. Then the proceedings of municipal body. Municipality is a state within the meaning of Article 12 of the Constitution. Panchayat is a state within the meaning of Article 12 because they are a state and instrumentality agency of the state. So they're all public officers who are discharging. Even a Grama Panchayat is a public officer. Then books, publication, so 5, 6 and all relating to years of documents, all issued by the public officer. Yes. Oh, yes. Then 6 may public document any other class of foreign country, namely the original copy of the legal keeper thereof with a certified copy of the notary public. The notary which has notarized a document, it has that can be accepted as a direct evidence, provided you tell the court it has been signed by the person who has done it here. It has been entered in the notary's register, and the notary's number is given there. Notary is a public officer, isn't it? An Indian counsel in a foreign country, you may be your brother, sister may be in a foreign country, London, America, Dubai. You are filing a suit for partition in India, Mumbai, Delhi, anywhere. You can get a power of attorney. A power of attorney prepared and sent from India, but that document, the power of attorney which you send to your brother, sister who are in a foreign country, that is required to be attested by the Indian council or ambassador of a country in the country. So that signature of the council is a public document. So you need not call the council an ambassador to come as a witness to depose whether the document is correct or not. Okay. So this is the latitude given in the matter. Then anybody want to ask any question before we go for presumption as a document which we had covered while dealing with section may presume, shall presume, and conclusive proof. I won't be wasting much time. I can cover this topic somewhere. I think in 2-3 lectures we'll be able to cover this, the entire evidence set. Presumption देख लीजिए आप. So the section 79, 80 and all, you have to read it along with the call shall presume. Section 4 में पढ़े आपने ना. What is a shall presume आपने देखा है. I won't be again repeating it here, but drawing your attention, what we learn, may presume, shall presume, conclusive proof. So shall presume के लिए, whenever it is directed in the court that the court shall presume a fact regarding a to, So rebuttal evidence can be laid. The court normally presumption arises. Genuineness of certified copy 79. See that certified presumption of genuineness of certified. A certified copy which you obtain from the registrar, a certified copy which you obtain from the Election Commission of India is presumed to be a genuine document unless the other side takes a contrary view and establishes no. So they have let to demolish here, isn't it? Presumption as a document, produce and record of evidence. Under section 80, I gave illustration. A confession recorded by a judicial magistrate under the CRPC 164, and he must record the confession and prepare a memorandum. Isn't it? You must tell the accused person that you are not supposed to give confession. If you give a confession that will go against you, I warn you not to give confession. So he is prepared to, he is supposed to make a memorandum of the confession. Then under the CRPC, the learned magistrate recording evidence of the parties under the trial, which is known as a trial before a court of session or a trial before the magistrate in a warrant cases. Magistrate is required to prepare a memorandum. So that memorandum is accepted as a evidence. The court shall presume it's valid because the magistrate is a judicial officer. He is not going to lie unless the other side takes up the plea that yeah, evidence wrong. I was suffering from insanity. I could not. Then the onus will shift upon it. Otherwise, in the absence of the other side taking objection, these documents will be admitted in the court of law as a matter of record. The confession, the police, the judicial magistrate who is recording confession, he has done his job properly. He is a judicial officer. The judicial officer, learned magistrate, has done committal proceeding. The case is not triable by him, the triable by the court of session. He has applied his mind. He has taken the charge sheet and record. He is transmitting the record from his court to the court of session. So he prepares a memorandum. That memorandum is evidence. You need not challenge it. There is no need unless you say that the proper procedure has not been followed. Okay. 81 में आ जाइए. Presumption as to gazette, newspaper, private acts of the parliament. The court shall presume all the document 81 के अंदर presume genuineness of every document purported to be of London Gazette, official gazette of so and so colony tendency. So I will take it here, London Gazette जगह our parliamentary gazette, the central government, state government and legislative bodies. So all the governments which are, because every bill is introduced in the parliament, Rajya Sabha, Lok Sabha, you cannot introduce the bill without being gazetted. The law, it cannot become an act unless being it gazetted. So gazette में आने के बाद ही law बनता है ना. So all these are public documents. The court shall presume these are genuine one. Parliamentary reports जा चुके हैं. Discussion हुआ है joint select committee के अंदर parliament में. So the law presumes that that particular official act has been performed. Okay. So the court presumes this has been done. 81A पे आ जाइए. Presumption as to gazettes in electronic form. The court shall presume the genuineness of every electronic record purported to be the official gazette, purported to be the electronic record, directed by any law to be kept in a person. Such electronic record shall be substantially in the form required by law and produced from the proper custody. Abhi now EVM machines are there for election record ke liye, and the election commission maintains the record and keeps them electronically. So you have to trust he is a constitutional authority under the scheme of the constitution. And the presumption arises the Election Commission of India has properly wrapped them up and kept them after election and has produced it. So under the Representation of People's Act, a challenge is made here that it is not done, fraud has been played. It's the other side to prove it. If the other side doesn't take up the plea of fraud and does not lead evidence in rebuttal, the court will presume that the Election Commission and his agents and the representatives have done a proper job. The court will presume that it has been properly wrapped up and kept. So the court presumes the document is valid. Okay. Then 82 आ जाइए. Presumption as to document admissible in England without proof of seal of the signature. ये इंग्लैंड की जगह यहाँ पे आयरलैंड ये जुडिशियल डॉक्यूमेंट है. the judicial officer, contractor. So I will take up the plea that here in India, the Supreme Court passes a decree, a judgment, and the High Court passes a writ of certiorari, a writ of mandamus, writ of quo warranto, a Supreme Court also passing an order under Article 141, 142 of the Constitution, which is sealed and sent to the lower court to act upon it. And it's a document, the court will accept it. Its act has been done properly. Unless somebody takes up the plea, the will is bogus. Then that evidence you are required. In a shall presume case, the other side, normally the court presume the document is correct because the official act has been properly done by the public officer. Unless the defendant or respondent takes up the plea, it's a fraudulent document. A document is not from the custody of the court, not from the custody of a public officer. Fraud has been perpetrated, and check the record, and you send someone who are like that option is given to. In the absence of rebuttal evidence, please note that rebuttal evidence means the other side is required to prove and dislodging that the evidence is wrong. अगर वो rebuttal evidence lodge नहीं करा defendant or respondent, the court will accept the plaintiff evidence. Okay. Then 83 पे आ जाइए. Presumption as to map or plans made by the authority of Government of India. All the plans we discussed this earlier also. I won't be wasting your time. So the government of the Google plans, the plans prepared by the Parliament, the geographical indication, the plans are prepared under the State Reorganization Act, under Article 123 of the Constitution. India is a union of various states. So उसके लिए बहुत सारे मैप बन चुके हैं, गूगल मैप बन चुका है. और स्टेट रीऑर्गेनाइजेशन एक्ट चेक करें 19 immediately after partition, several rajas and maharajas, nawabs were asked to concede to India. So that accession is supposed to be the court shall presume that it is a conclusive proof. वो हमने पढ़े 113 में पढ़ चुके हैं आपने. देखो 113 में पढ़ चुके हैं. Proof of cessation of the territory is a conclusive proof. It is a conclusive proof. The court shall presume that you will not be permitted to lodge any evidence to dislodge it. Okay. Then 84 में आ जाइए. Presumption as to collection of laws and reports of the decision. So Supreme Court decision are reported in SEC, AIR, Supreme Court reporter. All these decisions are been correctly reported. The court shall presume them to be correct and proved. Google में आ गए messages. Judgment पूरे report होते हैं. Now Karnataka High Court has given a judgment on talaq now. It is now, on women wearing what you call it, mask. So that is a valid judgment as per the Supreme Court, and it being sought to be challenged in the Supreme Court. So you need not examine the Chief Justice and the judges to prove they are correct or not. So the judgment which has been reported, which is brought to the notice of the court in emails and books, the court shall presume they are correctly recorded. Okay. 85 में presumption as to power of attorney. Now the court shall presume that every document purported to be the power of attorney to have been executed before the authenticated by notary public, court, judge, magistrate. So who are the officers responsible for attesting your power of attorney? The judicial officers, all magistrates. They can do that here. The councils, they can do that here. Representatives, notary public do that here. And Killa Court में Bombay के अंदर judicial magistrate first class does it here. In every judicial magistrate in every area they do that here. So if that is done, the court, it is presumed that the document has received the original seal of the court and it is a valid document. And normally the court shall presume it is a valid one unless the other side say that a bogus person was set up. The plaintiff has produced a document attesting at the time he was not in Mumbai. Actually, he's a dead person. He was not there, not alive. A dead person certificate is a fictitious person. That onus will be upon the defendant. That's called a rebuttal evidence challenging. अगर वो challenge नहीं होगा, तो section 85 के अंदर the court will accept the evidence as a court shall presume. 85. These are examples of a shall presume. Please read section 4 very clearly. 85. A presumption as to electronic agreement. The court shall now presume that every electronic record purported to be the agreement containing electronic signature. Parties are so concluded, affixing electron. Now everything transactions are taking place electronically. Now government of India also want to print the notes in an electronic way. What is the name it is called? Anyone knows that? Electronic notes? क्विटोकरेंसी क्या बोलते हैं उसको? So these are all electronic currency now already prevailing in foreign countries, the USA, UK. So abhi even arbitration, international arbitration, their discussion, all arbitration took place by virtue of electronic agreements. Because the present arbitration which is going on is similar to litigation. It's outdated, time consuming and very costly. Better to go for electronic way. Robot आके discuss सब decide करेगा. This has been this is subject matter of discussion in Dubai conference UAE. The Chief Justice and a brilliant speech of Justice Justice Chandrachud, who has said that here we must go for electronic arbitration through arbitration. And you must read the speech of Justice Dhananjay Chandrachud. It's a beautiful one. Even our Chief Justice has discussed, but Chief Justice of India discussed the various arbitration laws which were prevailing in India prior to the partition, Hindu Shastra or 1940 Act, 47 Act, this more or less the Uncital Act of 1992-97. But the speech given by Justice Dhananjay Chandrachud covers the electronic signature agreement, and arbitration should be based on that here. That's a very interesting. I will share with you all by this evening. You all should go through that. That arbitration has been proposed because he said that present arbitration is as good as litigation. See, you are not supposed to, under Section 5 of the Limitation Act, there should be minimum intervention of the court. But parties gadi gadi court mein jate hain. Under Section 9, interim orders can be taken at any stage, even before or after. Execution के लिए 34 के अंदर 36 में you go to the court. Again you for the 37 के अंदर भी appeal go to the court of law. 42 के अंदर go to the court. So as evidence you're not supposed to record. Evidence Act is technically not applicable to arbitration. But the arbitrators which I'm appearing in Bombay, they are recording evidence as they are deciding civil suits. And they are supposed to dispose of the arbitration within 2 hearing, 3 hearing. I mean, the matters are going on with donkey's years. 5 years, 10 years. Parties will become broke and the arbitrators' fees are very expensive. And the councils also want to demand a similar fees. So we are also working hard and we should also be paid. So as a result, parties will go bonkers. According to me, arbitration system is a big failure. Unless you reduce the fees of the arbitrator as well as the council. Number two, expeditiously take place. ये evidence का act का role ही नहीं है उसके अंदर. Why they are recording evidence like a civil court? All of you, many of you juniors and students must be watching it here. Arbitrators are recording evidence. Evidence Act is not applicable to arbitration. In fact, they are supposed to go to the court under Section 24, take the assistant. वो नहीं हो रहा है. So in the entire arbitration is taking as it is a civil suit under Section 9. So with great respect, it's a big fraud upon the legal system. So the Justice Chandrachud's speech in Dubai, in UAE, recently took place last week. You must read that. He must say that we must have an electronic way of proceeding in it's a robo system. It's an electronic device. You can finish it off in no time. That is something very unique. I was also puzzled, but I was very happy to read. I read his speech 2-3 times. I understood what he wants to convey, and it's a nice one. You all should go through that. 85A check करिए, presumption 85B में आ जाइए. Presumption as to electronic record and electronic signature. So then normally the court presumes that they have been done. Of course, यहाँ पे you don't require to follow the provisions under Section 65B secondary evidence. 65A the court will presume that the commissioner under the provision, the officer under the Information Technology Act has signed the document. So that is what here. Then 85C, presumption as to electronic signature certificate. So 85A, B, C, they deal with electronic. The presumption, the court shall presume that it's a valid document. the court shall presume it is valid document. Yeah, I will not accept this document. I will have to request someone not to give this call here. Somebody is trying my WhatsApp call. Yes, I will. Yeah. Yeah, please remember that here 85A, B, C, they're all dealing with the electronic presumption as to the court shall presume. There is no need to call for the electronic officer to prove it here. 86 is important. Presumption as to certified copies of a foreign judicial record. So foreign judicial record, a decree is passed in America, London, International Court. Huh? So under the provision of section 13 and 14 of the Code of Civil Procedure, when is a foreign judgment and decree is conclusive? वो पढ़े आपने? Isn't it? Both of you, you want me to draw your attention? 86 should be read along with section 13 college CPC का 13 and 14. When foreign judgment not conclusive, presumption as to foreign judgment. The court shall presume upon the production of a document purported to be certified copy of a foreign judgment. Such document was pronounced in a court of competent jurisdiction, unless contrary appears to be recorded, but such document may be displaced by proving whatever. So you have a right to, as a plaintiff, directly produce the seal of the foreign court. It will be admitted unless the defendant takes up the plea. No, I am challenging it. I am not consenting. Even under the provisions of the Arbitration Conciliation Act, Section 45 onwards, there's a provision, Geneva Convention, your convention award, when the award can be challenged and set aside when it is not by consent of the parties, when the law of the country is not followed, when the principles of natural justice are not followed, and is lacking in jurisdiction and not competency, the various ground. Otherwise, the judgment itself can be produced. It says 86. The court may presume. See, it doesn't say court shall, court may presume. यहाँ पे 85C से लगे the court shall presume के evidence 79 से लेकर 85C court shall presume है. Court shall presume. 86 is a may presume. May presume that the document purported to be the certified copy of a judicial record of a country forming part of India or of Majesty Dominion is genuine and accurate if the document purported to be certified in any manner, which is certified by the representative of the central government. Mind you that if a foreign country, America ke andar, London mein, if a decree is passed in your favor or against you, you cannot directly come for execution to Bombay, Calcutta, Madras. वो डिक्री को आप क्या करेंगे? You will take it to the Indian Council office first. Indian Council office will certify this is certified copy. See that Our Majesty Dominion genuine is a document purported to be certified copy, certified. So central government of India के लिए officer must sign it. So don't bring the certified copy directly to India or decree which is passed by a foreign country to India for execution in Bombay, Calcutta, Madras, Delhi, because a foreign decree can be executed. Anybody knows under the CPC, under what section and what manner? CPC पढ़े आपने? Anybody knows offhand? Anybody knows? 1 second, 2 second? I will give you 5 seconds. 3 more, 4, 5. It is section 44A. Under section 44A, two foreign countries. There is India has a relationship with a foreign country. Section 44A खोल लीजिए आप. Section 44A, decree which is passed by a foreign country. You have to remember this. Decree passed by execution of a decree passed by a court in a reciprocating territory, where the certified copy of a decree of a superior court, any reciprocating territory. Now, you have filed a, suppose, international arbitration किया आपने इंडिया क्या और फॉरेन कंट्री का. लंदन में अवार्ड पास हुआ. Your properties are sought to be attached in Mumbai, Delhi, Calcutta, Madras. Or decree directly, you cannot bring it to district court. So they have to be executed in a district court mean in the city of Bombay, the High Court of Judicature oversees the district court. The topmost civil court is a district court. दिल्ली के अंदर सेपरेट डिस्ट्रिक्ट कोर्ट है, पुणे के अंदर कल्याण में डिस्ट्रिक्ट कोर्ट है, बॉम्बे सिटी डजंट हैव ए डिस्ट्रिक्ट कोर्ट, बट फॉर द पर्पस ऑफ सीपीसी द बॉम्बे हाई कोर्ट एक्सरसाइजिंग ज्यूरिडिक्शन अंडर ओवरसीज इज ए डिस्ट्रिक्ट कोर्ट. वो डिक्री को आप अंडर सेक्शन 86 के हिसाब से you must go to the Indian consular officer in UK, USA, wherever he is, let he has to certify. Yeah, the plaintiff has obtained the award in a UK and he is seeking to execute in India. So in my, I have perused it. This copy is correct. वो लाने के बाद बॉम्बे में आप execution proceeding कीजिए. Under section 44A of the CPC, then only your execution proceeding will be valid. Otherwise, your copy will not be accepted. Please note that here. You must follow this procedure. Those of you are attending the international arbitration, you will know this. And mostly arbitration में ये सब बातें नहीं discuss की जाती because the provisions of CPC and Evidence Act are not strictly applicable to the arbitrators. But those arbitrators who have done trial jobs, many of them judges who were initially trial judges and trial court law, they will know very well. So you as a young lawyer, when you go for arbitration, or many of you youngsters don't want to practice in trial court, directly you want to go to Supreme Court and High Court. So as a result, you will not be learning all this. My request is that here all of you practice in trial court for 2-3 years. Simultaneously take up matters in High Court or even go to offhand Supreme Court. A trial court key knowledge is very important. If you don't have the backing of the trial court, you will be known as a shallow type of a lawyer. These are requirement. I have seen many judgments where the Supreme Court rejecting the execution application for non-fulfillment of the procedure under Section 86. Please note the ऐसा भी हुआ है. There are many decrees and many eminent lawyers appearing. They are not taken notice of this because they don't want to read it very particularly. वो होता है ऐसा. And we don't want to blame. We all human beings, we make mistake. But you as a young lawyer, read through the entire Evidence Act. Your Evidence Act and your CPC procedural law should be very perfect. Even if you are reading CRPC, CRPC may be provision, a reciprocal provision. How warrant of a one country can be executed in another country. How summons can be executed of the country. वो सब चीजें reciprocal arrangement है उसके अंदर, should know that. So यहाँ पे may presume शुरू हो जाता है. So when a decree which is passed in England, America, which is sought to be executed in India, you cannot directly bring it here. Following the procedure under Section 86, Section 14 Code of Civil Procedure, under the international arbitration rules of Geneva Convention and New York Convention or whichever Paris Convention, वो भी follow करना पड़ेगा. वो करके लाएंगे आप, then your decree will be valid under the Evidence Act. Then what is the time? If I'm not late, yes, another section we can cover till 90 तक, 90 तक. Then 91 में कल next time लेता हूँ. Till 98 तक cover कर लेंगे. Now 87 पे आ जाइए. Presumption as to books, maps and charts. This I read it to you. The court may presume. Now may presume शुरू हो गया. Section 4 के अंदर the court is a discretion of the court whether to accept it or not accept it. And I shall presume the court normally will accept it. It's a mandatory tone. Initially पट करके ले लेगी court. May presume में the court will tell you I may not accept it. You prove it to the witnesses. So यहाँ पे the books the chart. The court may presume that any book which may be referred to the information matters public or interest maps so and so. These are all private documents which are in the custody which are brought from the court, may be authentic source. You must have brought a book written by an eminent author where defamation you are filing, suit for defamation, claiming damages. Then court may say that prove it under the provisions of the. So this is the provision court may presume. The section 87, 86, 87 should be read along with 114. हमने पढ़ा सबसे by one of my first lecture was first second 114 where the court draws presumption, natural presumption. The court may presume certain facts. So I will be reading later on here. 87 हो गया है. 88 पे presumption as to telegraphic message. The court may presume that the message forward अभी telegraph तो बंद हो चुके हैं, but in the earlier messages which have been given by telegraph, the court normally says that your transmission has taken place. It's an official act. The court shall not make presumption. Abhi 88 is almost redundant because telegraphs have now been abandoned. Okay, but this is what you should know. 88A, presumption as to electronic message. The court may presume, again may presume. So the court is not bound to accept it. The court may say that yes, electronic message, ये email message, ये तुम्हारा WhatsApp message, which has been forwarded and coming to you from other sources may be correct. But you court will say that here, this you require certificate under the provisions of section 65B, following the judgment of the Supreme Court in अर्जुन पंडित राव खोटकर्स केस, वो फॉलो करना पड़ेगा आपको, अर्जुन पंडित राव खोटकर. So the court, you will be directed to lead evidence. The other side may even go for rebuttal evidence. This is wrong. This is to be proved here. So यहाँ पे 85, 89 presumption has to do execution of a document not produced. The court shall presume. Now अभी यहाँ पे 89 में shall presume हो गया. 88 तक ये 86 से लेके 88 ये may presume था. Now यहाँ पे again the court shall presume. This is a mixture of may presume and shall presume, starting from section 79 onwards. So 89 में देखिए, the court shall presume that every document called for and not produced after notice to produce was attested, stamped, and executed in the manner required by law. Now you gave a notice under section 66. That is, the primary evidence is in the defendant possession. You have a secondary evidence. और notice देने के बाद the defendant is not producing it, the court will presume the original document is in the custody of the defendant, which is suppressing. He is not producing deliberately because the document will go against him. So the court will draw presumption. See, section 89 should be read along with section 66 of the Evidence Act, notice giving requirement, 89 presumption drawing, and section 114G, the court will draw adverse inference. 114G check karo, 114 clause G में, that the evidence which could be and not produced, would if produced be unfavorable to the person who withholding it. So I gave the notice to you, or you gave me a notice to produce the original income tax record, which I am not producing it. You gave me a notice. I'm a builder. You are the flat purchaser. You produce the document, registered document, which is in a possession. I'm not producing it. So the court may draw adverse inference against me under 114G, and the court will accept my notice under section 66 and also accept my Xerox copy under section 63 and 65 of the Evidence Act, and the court shall presume that it is correct document. Please note that here, three sections are now connected here. Section 66, 63, 65, 89, 114G. To explain this document, you have to write it down with your pencil. ये notice के बारे में पढ़ चुके हैं हमने section 66 के अंदर. So the court presumes that the notice given by you is valid. And the defendant is deliberately not producing the document because that will go against him. So the court क्या करेंगे यहाँ पे? You will tell the court, please draw adverse inference under 114G. जानबूझ के produce नहीं कर रहा है. But the document can be taken on record. Now 90 में आ जाइए. Presumption as to document 30 years old. When any document purported to be of 30-year-old is produced from any custody which in the particular case consider proper, the court may presume that the signature and every other part of the document which purported to be in the handwriting of any particular person, of a person handwriting, and in the case of a document executed, attested, that was duly executed, attested by a person by whom it purported to be executed, attested. So section 90 ये कहता है कि a will produced by one of you is a 30 years old grandfather's great grandfather ka document. So you are not in a position to prove it under section 68, 69, 70. Yeah, that is what the evidence. But the court presumes 30 साल पुरानी document है, it is coming from proper custody and it appears to be genuine. The court may take into consideration unless the defendant say that it is a fraudulent document. I will lead evidence to show that This is not tallying the signatures. I will, I will, I will establish the fact that it's a bogus document. It's a sham, colorable bogus document. My uncle or brother has produced it to grab the properties. So the court may initially will accept it on record. The court may presume it being a 30-year-old document. It doesn't mean that contents are proved. If you don't take up the plea, it's not a bogus document. Chup chap rahenge, the court will accept the document. Please note that here. 30-year-old document है, election. अभी पुराना letter है, written by grandfather. To prove a particular custom, ग्राम पंचायत के आदमी ने कहा का इनका adoption हुआ था इस church में, इस particular मंदिर में, following the Hindu rituals or Christian rituals, and it's a 30-year-old document. So under section 90, the court will be persuaded to accept the document. Unless the defendant takes up the plea, it's a fraudulent document. It's a fictitious document. ऐसा कोई आदमी था नहीं, पैदा ही हुआ नहीं था. On that particular day, he was dead and gone. He was not there. That is the onus upon you. So may presume, shall presume के अंदर, this is connected to may presume document. 90. Explanation check कर लिया. Documents are said to be in proper custody if they are in the place in which under which the care of a person whom they will be naturally be, but the custody of improper is the property without. So if a will coming from the custody of a grandson is supposed to be a custody, because he will say, I was assisting my grandfather in the business. It was in the custody of my father. My father used to be very close to him. And my estranged uncle was in London, America. He was prosecuting. He had no connection. So the court will presume the custody is proper. The document coming from the custody of your spouses, husband and wife. Litigation takes place between family matters. Son, children, grandson are fighting over the co-parental rights. So a document coming from the custody of a person, the court presumes that yes. If it is coming from the custody of a stranger, how a stranger got the document? He has no connection. Neither he is a witness, nor he is related to him. ये डॉक्यूमेंट कहाँ से आया? Somebody XYZ from Jamshedpur, somebody from UP, somebody from Bangladesh or Pakistan or New Zealand who has no connection. No, any Tom, Dick and Harry cannot say that ये custody मेरे पास है. You must explain who you are. What is your proximity of relationship with the deceased? How you are connected to somebody not. Yes, if the accountant of the deceased says that the document in my possession, accountant is a person who normally maintain. A Mehtaji call accountant. An advocate, a solicitor maintain the record. Yes, he is a representative, legal agent. He is an agent. Or in a case of in the Indian Contract Act, relationship between principal and agency under 202 of the Indian Contract Act. So he is a person who maintains a record. I was the power of attorney holder in doing business 30, 40 years ago. So I did this transaction. Yes, you are a person coming from proper custody. Somebody XYZ having no relationship, no privity of contract, producing a bogus document, claiming a legal right. Who are you bolenge? You don't have a privity of contract. Okay. These are the section. Explanation applies to section 81. देखिए section 81 के बारे में presumption as to gazette के बारे में 81 के बारे में बोला है. Yeah. Then A has been illustration. A has been in possession of landed property for a long time. He produces from his custody deeds relating to land showing his title to it. The custody is proper. So the person, it is your property, your document. I have a trespass. I have trespass. And you are not taken action against me. Of course, I may take up the plea that I am the owner of the property, maybe by virtue of adverse possession. The court may take up the plea adverse possession is not proved under Article 64, 65 of the Limitation Act. So the plaintiff says that it was originally a document of my grandfather's property, and after his death, my father became the owner. Thereafter, the original documents, I took it to London when I was studying. There was a whatever reason maybe. So I am claiming a declaration, ownership right in the property. It may be declared that the defendant is a trespasser, he doesn't have right. So I am producing here with the 712 extract in the name of my grandfather. So it is coming from the proper custody. So the court will presume that here his grandfather died about 30-40 years ago. It's a document falling within the ambit of section 90. See, the court will presume that it's a genuine document because he's a grandson. A grandson is legitimately producing. Number B. A produces deed relating to landed property of which he is a mortgagee. The mortgager is in possession. The custody is proper. So under the Transfer of Property Act, section 58, 59, 60, 61, dealing with various mortgages, English mortgage, simple mortgage, usufructory mortgage. ये mortgage करेंगे आप normally. If my property I am mortgaged to you and taken loan, the law presumes that my documents are in your custody. You are a proper custody. Normally, mortgage suit is to be filed within the period of 30 years, पहले 60 years था. So not bothered, I not redeem my property, I not paid the back. So you may take up the plea that since I not redeem my property, you are entitled to foreclosure. Huh? You are entitled to the ownership unless I redeem the mortgage by filing a suit under order 34 of the Code of Civil Procedure, read with section 68, 69, 70, 72 of the Transfer of Property Act. I lose my interest. So a mortgage is a person rightful possession. Okay. Number C. A connection of B produces a deed relating to land in B's possession. A connection, which were deposited with him by B for safety custody, the custody proper. So B is a trustee acting in a fiduciary capacity. You kept in a bank locker, bank is your trustee. So these are all illustrations show that here they are proper custody. But if he's in the custody of your somebody unknown to you, so third party whom do not know, maybe a servant of servant, somebody's children who do not know, that custody is improper. So these are the examples with regard to the section 90. 90A में चेक कर लो क्या है इधर ना, यूपी का है, यूपी में अमेंडमेंट आई डोंट नो, सेक्शन 90 सेंट्रल एक्ट स्टेट में कुछ अमेंडमेंट है, where a registered document or a duly certified copy thereof, any certified copy which is a part of the record of the court of justice is produced from the custody of the court, the particular case considered proper, the court may presume that the original was executed by a person by whom. Yes, या यूपी के अंदर कुछ अमेंडमेंट है उत्तर प्रदेश में with regard to certificate. Okay, it's not necessary because already covered by other section. 90A में आ जाइए. Presumption as to electronic record 5 years old. So normal documents are 30-year-old, and as regard the electronic record 5-year-old. Where any electronic record purported or proved to be 5 years is produced from any custody, which the court in particular case consider proper, the court may presume that the electronic record which is purported to be electronic record or any particular person so fixed by him or authorized by him in this behalf. So the police has registered a case of suicide of a particular man who was staying in a hotel. समझे आप? Electronic record, the CCTV camera was gathered by the police officer. Inquest Panchanama was done under the provisions of section 174-75 CRPC. Collection evidence recorded. So a CCTV camera, normally in a criminal trial, from magistrate के पास matter आने के बाद session triable case transmitted after 5 years के बाद recorded. The court presumes that the CCTV camera which has been recorded by the police officer under the supervision of 2 panchas and the hotel staff is a valid document. Is a presumed because under section 100 CRPC, read with 100 subclause 2, the police officer can ask the panchas, 2 panchas to remain present for the purpose of taking down the articles which he has taken searches, or an accused person making a confession in his presence under section 27 of the Evidence Act, pursuant to which recovery is made. The police officer recorded CCTV camera or record. Hospital में मालूम हुआ कि this man committed suicide, somebody attacked him, whatever reason may be, is electronically recorded, so that evidence can be proved by before the court. Even after 5 years, the court presumes is a correct document. Of course, the police officer must have obtained certificate under section 65B of the Evidence Act under the information technology. Otherwise, the court presumes this is a proper explanation. The electronic record are said to be in proper custody if they are in the place in which under the care of a person with whom they are naturally be, but no custody is improper if proved to have been legitimate origin segment. So normally when a police officer conducting investigation under the CRPC, he keeps in the safe custody or he will deposit it with the magistrate. Because no sooner an article is collected by the police officer, he must transmit the document to the magistrate. So a custody of a magistrate is a judicial custody. So by no stretch of imagination, it can be said that the document is maneuvered or fabricated. But yes, the accused person has a right to say that it is not the same record, same CCTV camera as was done earlier. It may be different. The procedure has not been followed with. But the presumption arises 5 years document old, the court shall presume this is a proper document. Okay, आज का topic बंद. Anybody want to ask me question tomorrow? Whenever we take lecture tomorrow, day after tomorrow, 9 कल का नहीं रखेंगे, कल Wednesday. I'll take on Thursday. We'll take 91, 92, very interesting topic. When there is a written document, are you permitted to lead oral evidence? There's a prohibition, you cannot lead oral evidence when there's a written document. But in certain cases, you are permitted. What are the cases? 90, 91, 92, till 99 tak lenge. Anybody has any question in today's lecture, please inform. समझ में आया lecture? Yes, बताइए.
Sir, I had a question related to your previous lecture with respect to section 63.5. Sir, you said that or secondary evidence can be given by a person who has seen the document to be executed personally. He can give testimony with respect to the contents of the document. Sir, is that a section only limited to the other witnesses, or the attesting witness can also testify to the extent of document contents of the documents?
Oral accounts of contents of a document given by some person who has himself seen it. Suppose you have seen your grandfather signing the will, you can say that I have myself seen it, I was a witness. A servant can say that मेरे सामने साइन किया था साहब ने. समझे ना? So it's the oral content of a written document.
Yes, sir, but I'm asking whether a testing witness can testify to that extent, or because a testing witness can
under 65C, a testing witness will not come. Somebody who has not seen it. 65C के अंदर he will come under 68, 69, because he is a person who is a signatory. Somebody who is a non-signatory, 65C, देखिए आप, sorry, 63.5. That is the oral account of the content of a document given by the person who has seen it. A is the testator, B and C are the witnesses. C is a servant of the testator. He has seen it. He will come under 63.5. A hibanama of a Muslim, understood, no? The person who has signed himself will come under 68, 69. समझे ना आप?
Okay, sir.
Okay.
So one more question. What I have seen while I was interning at place. So with respect to electronic records, they do not, like police officer has registered FIR on electronic record. They do not seek a certificate from information technology officer. They just produce it, the contents of the certificate themselves and sign it. So is that practice legit?
Arjun Pandit Rao Kotkar's case is mandatory. Please note that. It's a 3-bench judgment of the Supreme Court. You can raise objection. The electronic record which is produced without certificate not admissible unless it is the original document. Suppose आपके मोबाइल से आपने पूरा सीन खींचा है, it's a original document. It will come under 65A. But आपके मोबाइल से आपने transmit किया to XYZ. Suppose I received it email message from you. That message which I am receiving from you is falling under 65B, which requires certificate under 65B subclass 4. Transmitted messages are secondary evidence, but something which is copied from the original is the original document. But you have to prove it. ये original mean मेरे मोबाइल से मैंने ये पूरा खींचा है. Who will go with that? This is done from your mobile, only the information technology officer. Otherwise,
Okay,
whatever written down by the police officer is inadmissible. You can take up the plea. Arjun Pandit Rao Khodkar's case, 3-bench judgment is the answer. For your answer, please go through Arjun Pandit Rao Khodkar's case. It's an election matter which arose from Maharashtra. It's a very interesting judgment. All of you should go through. If you want me to discuss, we'll discuss after our lecture. Yeah. Or kuch?
Yes, sir. One last, sir.
Sir,
Sir, are the newspaper reports admissible in court of law strictly as per
Certainly
evidence?
not. Certainly not. Evidence Act excludes it. Because Evidence Act says that the person who has seen must come before the court. Section 60. Padhan aapne? Direct evidence. Newspaper evidence is not evidence. The reporter must be examined. Who collected it? Kahan se liya? Kahan se information mila? What is your source of information? Okay. Section 60. Direct evidence must be direct.
Yes.
Of a person who sees it, a person who perceives it. और बताइए.
Okay.
Sir, as you said, young lawyers should practice in the lower court first. They cannot. If they're supposed to learn from the lower court, then after they approach the
Because
higher court. But
trial
sir,
takes place only in lower court, my dear. Supreme
yes,
Court
sir.
में, High
Sir,
Court में trial कहाँ होता है?
sir, this is the question. Sir, there should be need for the ARO, like those who are the ARO advocate on record. They have the capacity and they only can fight for client in the High Court and Supreme Court.
Then AR mean the advocates on record. See, the Supreme Court में there is no bar. Anybody can argue and appear. But only appearance can only be filed in Supreme Court by the person who has given examination, who knows the Supreme Court rules. उसके लिए exam. But for arguing, there is no bar. Anybody can argue. Any Tom, Dick and Harry can argue. Petitioner in person can argue. Any lawyer can argue. He can be called as a counsel can argue. Even IAO in advocate and record can argue. There is no bar. But appearance wakalatnama cannot be filed in the Supreme Court by everybody unless you are a person who gave the examination of AOR, advocate on record. And High Court में वो requirement उड़ गया. पहले High Court में भी था original side में. But you have to give a certificate. I have a clerk working under me. I know the rules. A certificate is enough. That rule has been now dispensed with in the High Court. पहले High Court में भी था पहले वो. अभी जरूरत नहीं. For practicing in High Courts and lower court, you don't require to give any special exam, except in Supreme Court, where you are required to give the advocate on record examination. But as a counsel, argue the case, there is no bar. You can always argue.
Sir, last question. Sir, like in the hit and run case, we have seen in the lower court, magistrate court and all. So police collect the evidence based on the CCTV footage. And the stage of cross-examination, the accused is acquitted from the charges. Basis of they corrupt the CD and they corrupt the all evidence. So, sir, they don't produce the certificate even. The prosecution also not.
No, they are producing. Now, in many
authentication
cases,
of-
they are producing in many cases. Now you see the present cases, they are producing it. In earlier cases, the police were not aware of this provision. Now they are producing it. Now you please sit in the trial court and see, watch carefully. But when you are a lawyer for the prosecution, you must tell the court it must be sealed and kept in a place under seal, and it should not be tampered with. In the High Court, we tell the court it may be kept in a sealed custody of the Prothonotary Senior Master, Registrar ke paas. The document should not be, the evidence should not be tampered with. But many times in magistrates court, sessions court में अब वो document खराब हो जाते हैं and documents cannot play. As a result, you cannot prove it. Accused is acquitted. You are right here. Many times वो recording लगाएंगे, the judge cannot even see it. बोले document is eroded. खराब हो चुका है. It is not well maintained by the police. It is junk. It's a piece of paper. It is not even worth. That is how in the criminal case the conviction level is very low. बस हो गया ना आज के लिए, और कोई क्वेश्चन है? Now next lecture will be not tomorrow, day after tomorrow. Tomorrow is Wednesday. I'll be busy with some other matters. Thursday को रखेंगे.